Hello, welcome to the show. I am Jacob Davidson, and I am a legal layman in North Texas. And this is a show where I try to learn the law and educate while I learn. It is nice to see everyone. I'm late. I was chowing down on a one bar, and I was preparing some tea. So I decided a little tardiness is hearty. There we go. Yeah, a little tardy is hearty. Everything looks good on every other end. And the lag on Rumble is intense. Uh, did I not? Damn it. It might. I might not have. Uh, okay. Rumble, you starting? Uh, well then. Well, I don't know what to do about that. Do not. Okay, reconnecting. It says streaming. Okay. Alright, there we go. Rumble is active. I gotta be aware of what I do with my fucking mouth. Holy shit. Alright, there we go. Man, it takes Rumble an age for the video to finally load up. It's kind of insane. So, hey there. How you doing, guys? I'm late. And that's on me. I was starting up my tea and eating something. So today, I learned something very cool. Devil May Cry is back. Nah, but qualified immunity might be out the window. That's cool. Uh, as it turns out, there is a possibility the original law itself was misread and misapplied because of that misreading. So, qualified immunity or cops might be liable for being sued. There it is. There it is. I'm catching some current events. Current photos show that the American flag appears to be flying upside down. So the flag at the Capitol building was upside down for a moment. That was interesting. All right, enough. God damn it. Enough of this. Time to get to the topic. Get to the topic. So, if you watched Rekieta's show, you've already heard this, but I'm going to go in depth into it. So, we go to the topic, and away we go. Oh yeah, and sorry for not doing the President Trump speech on January 6th like I was going to, but the past can wait in the past a little bit longer. This seems very current, and I am very interested. "16 crucial words that went missing from a landmark civil rights law. The phrase seemingly deleted in error undermines the basis for the qualified immunity, the legal shield that protects police officers from suits for misconduct. In a routine decision in March, a unanimous 3-3 judge panel of a federal appeals court ruled against a Texas inmate who was injured when the ceiling of the hog barn he was working in collapsed. The court predictably said the inmate could not overcome qualified immunity, the much criticized legal shield that protects the government officials from suits for constitutional violations. The author of the decision, Judge Don R. Willett, then did something unusual. He issued a separate concurring opinion to draw to attention the game-changing argument in a recent law review article, one that seemed to demonstrate that the Supreme Court's entire qualified immunity jurisprudence was based on a mistake. Wait, what? Judge Willett wrote, incredulous. In 1871, after the Civil War, Congress enacted a law that allowed suits against state officials for violations of constitutional rights. But the Supreme Court has said the law, usually called Section 1983, did not displace the immunities protecting officials that existed when the law was enacted. The doctrine of qualified immunity was based on the premise. But the premise is wrong, Alexander A. Reinhert, a professor at the Benjamin N. Cardozo School of Law, wrote in the article "Qualified Immunity's Flawed Foundation," published in the California Law Review. Of course, the most groundbreaking law articles not given by fucking Harvard or Stanford law. Between 1871, when the law was enacted, and 1874, when a government official produced the first compilation of federal laws, Professor Reinhert wrote, 16 words of the original law went missing. Those words, Professor Reinhert showed that Congress had indeed overridden existing immunities. Judge Willett considered the implications of the finding. What if the Reconstruction Congress had explicitly stated right there in the original statutory text that it was nullifying all common law defenses against Section 1983 actions? Judge Willett asked, that is, what if Congress's literal language unequivocally negated the original interpretive premise for qualified immunity? The original version of the law, the one that was enacted in 1871, said state officials who subject any persons within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunity secured by the Constitution of the United States shall any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding, be liable to the party injured in any action at law, suit, in equity, or other proper proceedings for redress. Legal notwithstanding. Wait. Yeah, that was legal notwithstanding. Create exceptions to the rule of a contract. Despite in spite of. The words in italics, for reasons lost to history, were omitted from the first compilation of federal laws in 1874, which was prepared by the government official called the Reviser of the Federal Statutes. The reviser's error, whether one of omission or commission, has never been corrected, Judge Willett wrote. The logic of the Supreme Court's qualified immunity jurisprudence is that Congress would not have displaced existing immunities without saying so. But Professor Reinhert argued that Congress did say so in so many words. The omitted language confirms that the Reconstruction Congress in 1871 intended to provide a broad remedy for civil rights violations by state officials. Professor Reinhert said in an interview, noting that the law was enacted soon after the three constitutional amendments ratified after the Civil War to outlaw slavery, insist on equal protections, and guard the right to vote. Along with other contemporaneous evidence, including legislative history, it helps to show the Congress meant to fully enforce the Reconstruction Amendments via a powerful new cause of action, Professor Reinhert said. Judge Willett, who was appointed by President Donald Trump, focused on the words of the original statute in his text-centric judicial era when jurist profess unswerving fidelity to the words Congress chose. Qualified immunity, which requires the plaintiff to show that the officials had violated a constitutional right that was clearly established in a previous ruling, has been widely criticized by scholars and judges across the ideological spectrum. Justice Clarence Thomas, for instance, wrote that it does not appear to resemble the immunities available in 1871. Professor Reinert's article said that it's only half the story. The real problem, he wrote, is that no qualified immunity doctrine at all should apply in Section 1983 actions if courts stay true to the text adopted by the enacted Congress. Johannes Schwartz, a law professor at the University of California, Los Angeles, and the author of Shielded: How the Police Became Untouchable, said there is a general agreement that the qualified immunity doctrine as it currently operates looks nothing like any protections that may have existed in 1871. The new article, she said, identified additional causes for skepticism. She added that Judge Willett's concurring opinion has brought much needed and well-deserved attention to Alex Reinhardt's insightful article. Judge Willett wrote that he and his colleagues are middle management circuit judges who cannot overrule Supreme Court decisions. Only the court, he wrote, can definitively grapple with Section 1983, enacted text and decided whether it means what it says. Lawyer for the injured Texas inmate Kevion Rogers said they are weighing their options. The scholarship that Judge Willett unearthed in his concurrence is undoubtedly important to the argument that civil rights litigants can make in the future. The lawyers Matthew J. Rekieta and David Matthias said in a statement, normally they added, you cannot raise a new argument for reversal for the first time on appeal, much less at the Supreme Court of the United States. But one would think that if the Supreme Court acknowledges that it has been reciting and applying the statute incorrectly for nearly a century, there must be some remedy available to litigants whose judgments are not yet final. And honestly, I think Trump should run with this. If a Trump appointee saw this, made a concurring opinion to point it out and show it, then I honestly think that Trump should run with it. And now I know it might defy the approach of what's it? It might defy the approach of law and order. However, if Trump is smart in his run for 2024, he should be able to work it as a law and order argument that this applies law when law is undone by an officer of the government. This is a fantastic way that he could stand with law enforcement and stand with the citizens. Qualified immunity might be overdone, and it makes me so excited. I just arrived, Superman tights and all. Welcome, NC Native. Welcome. Welcome to City 17. You have been chosen or chosen to relocate to the finest urban... Found the stream link written on a bathroom wall of a shady strip club. Oh god, I hope so. That means more people are watching my streams than normal. Do it. Write my fucking name on the bathroom stall of a shady strip club. Or, yeah, write the stream name. Dude, qualified immunity might be fucking gone. Okay, so this is just a PDF version of that. Alright, I'll be going through this 46-page Qualified Immunity Flawed Foundation document from Alexander A. Reinhert, a Max Freund Professor of Litigation and Advocacy, Benjamin N. Cardozo School of Law. Well, why didn't he give me answers? Hold on, I gotta fucking... Gotta find the thing again. Shall, okay. Uh, let's say italicized. Alright, I wanted to tell people. Oh no, he died. Well, damn. Why didn't he live long enough to give me the answers? I don't know. Alright. So yeah, let me just reread that. Any person within the jurisdiction shall have privileges. Deprivation of any rights, privileges, or immunities secured by the Constitution shall any such law, notwithstanding, be liable. Alright, time to get into this fucking law review article. Let's go! I like telling my friends about stuff I learned, so I'm gonna head out again, but I'll keep listening to you for about 30 minutes. So Alex is an answer hoarder. You're trooper, layman. Stormtrooper, better aim. God damn it. You little bitch. Alright, so Qualified Immunity's Flawed Foundation by Alexander A. Reinhert. Qualified immunity has faced trenchant criticism for decades, but recent events has renewed focus on this powerful defense to liability for constitutional violations. This article takes aim at the roots of the doctrine, fundamental errors that never have that have never been excavated. First, the article demonstrates that the Supreme Court's qualified immunity jurisprudence is based on a flawed application of a dubious canon of statutory construction. Namely, the statutes in derogation of the common law should be strictly construed, applying the derogation canon. The court has held that 42 U.S.C. 1983 silence regarding immunity should be taken as an implicit adoption of common law immunity defenses. Derogation canon. I will look this up for you because I have no idea. In canon law, in terms of Catholic canon law, in this context differs from dispensation in that it applies to law, whereas dispensation applies to specific people affected by the law. Fuck, what is derogation law? I guess I should go back to the Wikipedia. Black's Law Dictionary defines derogation as the partial repeal or abolishing of a law as by a subsequent act which limits its scope or impairs its utility and force. It is sometimes used loosely to mean abrogation as in legal maxim. Alright, apply the derogation canon. The court has held up that 14 U.S.C. silence regarding immunity should be taken as an implicit adoption of common law defenses. As this article shows, the derogation canon has no appropriate role to play in interpreting. Oh. So applying the derogation of the derogation canon, the court has held. Okay, so the derogation canon has no appropriate role to play in interpreting Section 1983. Courts and scholars have called it into question for more than a century. Even when courts have applied the canon, they have used it to disfavor displacement of common law claims, not common law defenses. And the derogation canon operates in inherent tension with contrary canon remedial statutes, like Section 1983, should be given a broad reading. The article also identifies a second significant failing in the court's qualified immunity law. For even if the derogation canon validly applied to defenses, the Reconstruction Congress that passed Section 1983 meant to explicitly displace common law immunities. Most critically, scholars and courts have overlooked the importance of the original enacted version of Section 1983, which contained a provision that specifically disapproved of any state law limitations on the new cause of action. For unknown reasons, the provision was not included by the reviser of the federal statutes. In the first compilation of federal law in 1874, the article is the first to demonstrate the implications of the lost text of Section 1983. Taken together, these twin insights show the problems with the court's immunity doctrine run deeper than prior scholarly criticism has imagined. Much of the current qualified immunity scholarship has addressed in compelling fashion how the court has taken the immunity doctrine too far from its common law origins. But the article shows that qualified immunity is flawed from the ground up. In other words, the problem with current qualified immunity doctrine is not just that it departs from the common law immunity that existed in 1871. The court has failed to grapple with the strong arguments that no immunity doctrine at all should apply in Section 1983 actions. So we got introductions, Pearson and the emergence of modern qualified immunity, an intellectual and doctrinal history of derogation canon. Oh God. Oh. This is a shortened version of a law review article. Holy shit. Hold up. Qualified immunity. The affirmative defense available to government officials sued in damages for violations of federal law is under renewed assault. Critics who otherwise shared little common ground attack the doctrine on multiple grounds. 1. Scholar and practitioners claim that it imposes insuperable barriers to relief in important civil rights litigation brought under 42 U.S.C. 19 subsection 1983 and other federal law. Others argue that immunity doctrine is inconsistent with Section 1983 text and purpose. Constitutional theorists question the gap it leaves between rights and remedies. So Sotomayor and Clarence Thomas have each criticized the doctrine in recent years. Oh, I guess give Sotomayor some credit. Also, some credit. Advocacy organizations with a wide range ideological commitments have joined in amicus briefs urging that the doctrine should be reconsidered. Brief for Institute for Justice, Cato Institute. All right. Gotta zoom in a little for these. Are documents vectors? Vector ducts? Uh, Briefs for cross ideological, and then 2. Thomas L.J. Describing civil rights attorneys' perception that qualified immunity can be a substantial obstacle to success. Uh, Arguing that qualified immunity doctrine unnecessarily subordinates constitutional protections to interests of governmental efficiency. Ooh. All right. So, an empiricist call into doubt its effectiveness as a matter of policy. This is only a brief rehearsal of the doctrine's alleged failings. The article adds, heretofore unexplored critical or critique, there is no foundation to the interpretive premise upon which qualified immunity rests. The methodology the court used to create the doctrine, the canon of construction disfavoring implied repeal of the common law, was never a legitimate ground for importing common law defenses into newly created statutory rights. Canon of construction disfavoring implied repeal. Is never a legitimate ground for importing. Okay, yeah. And when the court applied this flawed methodology to its interpretive task, it made a second mistake. It disregarded the explicit, albeit obscured, statutory text of the 1871 Civil Rights Act, the original version of Section 1983, which speaks to the Reconstruction's Congressman's intent to create liability for constitutional violations and displace any existing common law immunities. The Supreme Court has never explained how this text can be squared with the court's immunity jurisprudence. This article is the first scholarly effort to excavate Section 1983's original language and explore its significant implications. Qualified immunity, as the name implies, is conditional. Unlike absolute immunity, which bars recovery regardless of how egregious the legal violation. That section C Stump versus Sparkman. Or a Spittler Mark McFarlane represented a petition for the sterilization of her mildly mentally disabled daughter, Linda Sparkman, to the judge Harold D. Stump. Judge concluded sterilization was in Sparkman's best interest due to her mental capacities. The operation was performed although Sparkman was unaware of the true nature of the surgery. 2 years later, after Sparkman married, she discovered that sterilization explained her inability to become pregnant. Sparkman sued Judge Stump for violating her right to due process of law under 14th Amendment. The district court held that although the approval of the petition was erroneous, he had jurisdiction to consider that the petition was entitled to judicial immunity. 3 generations of imbeciles. Aura, you are a fucking bitch for this. A fucking whore. Okay. Alright. Well, hmm. Back to it then. 7. Qualified immunity contemplates that damages may sometimes be recovered against governmental agents or government officials. The court introduced the doctrine in 1967 decision involving Mississippi police officer Pearson v. Ray, where the court held that the 42 USC 1983 incorporated a good faith immunity defense that protected government officials from liability at common law in 1871. When Congress enacted Section 1983, much of Pearson's logic flowed from the court's decision in Tinney versus Brandove, which held that Section 1983 did not abolish legislative immunity recognized at common law. Since Pearson, the court has modified the extended qualified immunity doctrine. The doctrine now protects officers regardless of their good faith, so long as they behave reasonably in light of their clearly established law. And Pearson v. Ray is where's the OAS version of it? Not to rely on fucking Wikipedia. The policeman is not so unhappy that he must choose between being charged with dereliction of duty if he does not want to arrest when he had probable cause, and being mulcted in damages if he does. Ooh. Magical Girl Mars tastes pretty good. Case refers to the incident in Jackson where 15 Episcopal priests were arrested after entering the coffee shop at local tramway bus terminal. The group were part of 28 priests from Episcopal Society for Cultural and Racial Unity, taking part in the Mississippi Free Ride traveling from the Deep South to the Great Lakes. They left the following day on a charter bus. They were then split into 3 groups traveling. On a group of 15, including 3 black priests, took taxis to Kogalo and to the nearby Jackson Trailways bus terminal to catch the bus to Chattanooga, which entered the coffee shop to have lunch before their departure. They're stopped by 2 policemen officers. Captain J.L. Ray arrested and jailed all 15 for breaching of peace, using now repealed section code of Mississippi law that makes guilty of the misdemeanor who congregates with others in public place under circumstances such that a breach of peace may occasion thereby and refuse to move on when ordered to do so. God. Civil rights era was a fucking nightmare. Critics have long argued that the modern extension of qualified immunity is an improper form of federal common lawmaking. These ideas have gained traction recently. Justice Clarence Thomas has expressed openness to arguments that the court's immunity doctrine is an illegitimate judge-made law that departs from the common law defense that existed when Congress enacted Section 1983. On some occasions, this criticism means that the court must abandon the current qualified immunity doctrine in favor of the immunity that existed circa 1871. These critics accept Pearson's logic that Congress meant to adopt the good faith immunity that existed at common law because of what I call the derogation canon. The canon of statutory interpretation that statutes in derogation of common law should be strictly construed. If Congress meant to overrule the common law doctrine of qualified immunity according to this account, it would have done so explicitly. Honestly, even if it doesn't say it, or if it doesn't say it, I feel like a good rule of thumb would be if it doesn't say it, it's not real. If they wanted to add it, they will add it. $15. All right, so 14. Thomas, we should read 13 and 14 as well. Thomas J. concurring in part and concurring in the judgment. Thomas J. dissenting from denial of cert. And Scalia J. dissenting. As I have observed earlier, our treatment of qualified immunity under 42 U.S.C. 1983 has not parted or purported to be faithful to the common law immunities that existed when 1983 was enacted, and that the statute is presumably intended to subsume. Include absorb something in something else. Thomas J. dissenting from denial, regardless of what outcome would be, we at least ought to return to the approach of asking whether immunity was historically accorded to the relevant official in analog situation at common law. The canon takes many forms, including one, the idea that common law is not, or that was from Scalia, or from Thomas, and the footnote 15, which is strictly construed. This canon takes many forms, including one, the idea that common law is not to be overruled by implication, and two, the presumption that the common law supplies the default rule against which Congress legislates. See Comcast Corporation using default rule formulation. United States versus Texas. In order to abrogate the common law principle, the statute must speak directly to the question addressed by the common law. General quotation marks omitted. For purposes of this article, these formulations all are considered part of the derogation canon. The derogation canon. Just gonna do this. I do. gonna post this in the local chat since I feel like they don't know that I'm streaming right now. Cannot wait for Rumble to make the Rumble Rants mobile. It's not the best, but it's not the worst. I don't mind it so bad, so much. 15, alright, then 16. If Congress meant to, they would have done so. But criticism is only half right. Wolbald, among others, correctly observed that current qualified immunity doctrine departs significantly from common law principles. This said, it does not follow the rejecting of the court. It does not follow that rejecting the court's certain current qualified immunity doctrine requires a substituting whatever immunity doctrine existed common law in 1871. This is so for several reasons that scholars have overlooked. First, as a matter of interpretive methodology, the derogation canon is a tenuous one upon which to base any importation of immunity doctrine into Section 1983. At the time Congress passed the Civil Rights Act, influential treaties called the canon into question, given its roots in judicial supremacy world in which courts viewed common law as a font of perfection and were skeptical of parliamentary intervention. The criticism has only ever grown over time. In 1908, Roscoe Pound amplified the concerns about the canon's legitimacy, concluding that its archaic notions of interpretation made it wholly inapplicable to and out of place in American law of today. I'm getting solicited for stream stuff. Gotta fucking click these in their order. Roscoe Pound amplified the concerns about the canon's legitimacy, concluding that its archaic notions of interpretation made it wholly inapplicable to and out of place in American law of today. And while the Supreme Court was relying on the canon in its mid-1950s and 1960s decision regarding immunity in Section 1983, scholars were debating its validity. In modern times, the late Justice Antonin Scalia has been one of many who have criticized application of the canon. Indeed, it is ironic that the justices have invoked the derogation canon while claiming to give effect to the Reconstruction Congress's original intent in passing Section 1983, given that the canon itself aims to limit the power of the legislature and enhances the power of the judges. But even if one accepts the derogation canon should guide statutory interpretation, applying the canon to Section 1983 is questionable. In general, outside of the criminal context, courts have relied on the canon to disfavor displacement of common law claims or rights, not common law defenses. And derogation canon stands in tension with the presumption that remedial statutes should be read broadly. This is especially so for statutes that, like Section 1983, created rights of action in new substantive areas of law. It is thus no surprise that from the founding era until Reconstruction, the derogation canon was never used as a means to dilute statutory rights by implying a common law defense. And even after Reconstruction, courts used the canon primarily to protect pre-existing rights at common law from statutory incursion. Reconstruction era legislatures would thus have had no reason to believe that the courts would incorporate common law defenses into Section 1983's newly created cause of action. Just gonna let him down gently and slam him to the ground, you know? As one does when rejecting a business offer. Encoding overload hit up just a moment ago. You guys good over there? Would thusly have had no reason to believe that the courts would incorporate common law defenses in Section 1983's newly created cause of action. Putting aside these compelling reasons for concluding that the derogation canon is an inappropriate vehicle for importing common law defenses into Section 1983, there is a second piece of evidence demonstrating that the court's immunity jurisprudence is a profound misadventure. The Reconstructions adopted explicit text that displaced common law defenses when it enacted the original version of Section 1983. To appreciate this point, one must dig beyond the conventional analysis of Section 1983. Most critically, scholars and courts have overlooked the importance of the version of Section 1983 that Reconstruction Congress enacted in the Civil Rights Act of 1871. Created a cause of action for violation of federal law by state actors, what we now call Section 1983, and made clear that such claim would be viable notwithstanding any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary. For reasons unknown, the critical clause for purposes of this article I will call it the notwithstanding clause. Was omitted when the reviser of the federal statutes, who lacked any authority to alter positive law, published the first compilation of the federal law in 1874. The error was compounded when the revised statutes were collected in the United States Code, but because the common law of immunity for state actors, to the extent any existed, was generally state law immunity, Sections 1983's original text conveys congressional intent that immunity defense should not apply to the newly created civil rights action. What's more, this reading is confirmed by contemporaneous legislative history and other provisions of the Civil Rights Act of 1871. And here, I will find a very good place to pause and take a small break. And while I'm taking that break, I will present to you the Dragon's Treasure, a haven for anime and tea lovers. It's what I've been drinking throughout the stream. I have to say, Magic Girl Mars. Not a big fan of it, really. It's not the worst, it's not the best. It's alright. It's just good tea. Tastes good, but it's not my favorite. Also, I need to pour the rest of this in before it gets cold. Ingredients: honeybush tea. Hold on. Cocoa nibs, rose hips, cinnamon bark. It's worth trying out. But of course, it's also worth trying out with code Layman at checkout. Will get you 10% off of the purchase. And it's not just this tea, it's every other tea, even the Dragon's Treasure membership, which you will need if you want to get any herbs and spices of your own, and members only tea. There are some members only tea. I will show you one of them or two of them. Butterscotch is a holiday tea, and it's a members only. It's pretty good. It tastes like cinnamon. I actually really enjoyed it. Lime White, a members only, which has white tea, calendula, and natural flavors. Slightly acidic lime flavor mixed with the smooth notes of white tea. Remember, code Layman gets you 10% off of all of these purchases, including the Dragon's membership, the Dragon's Wing membership. So please, you can find it in the description below. If you're looking for some tea and some tea to try out, you can get a sample pack. Remember to use code Layman at checkout for 10% off your purchase. Alright, here I'm gonna go to camera and distract myself with non-stream related stuff and talk about for a moment. Just relax. Talk about the absolute horseshit that was a misinterpretation of the courts. Hold on. Some shit got promoted. Here we go. Up to the top, refresh. I'm on Twitter right now, you know, because I need a moment. 7 pages, and it's already a whole lot. I got 7 pages in an hour. So if I can do 7 pages in an hour, and it takes me, and this is 46 pages, 46 divided by 70, or 7. It'll take me about 7 hours to read through this whole fucking thing, if I don't pick up the pace. Should probably go ahead and say, fuck the state, free Zachariah Anderson, from what I've been hearing. People are very mad about Zachariah Anderson's bullshit. Oh, lives TikTok, you magnificent little beast. Huh. Freedom. Alright, back to it, bitches. Here we are. Here's that chat. Take a shit. Here we are. Back to it. Okay, notwithstanding, the error was compounded when the revised statutes were collected in the United States Code, but because the common law of immunity for state actors to the extent it existed was generally state law immunity, Section 1983's original text conveys congressional intent that immunity defenses should not apply. Now, yeah, right, ended at 1871. In other words, the problem with the current qualified immunity doctrine is not just that it departs from the common law immunity that existed when Section 1983 was enacted. As scholars have argued, and at least Justice Thomas has hinted, that is true. But it is only half the story. The real problem is that no qualified immunity doctrine at all should apply in Section 1983 actions. If court stays true to the text adopted by the enacting Congress and other evidence of legislative intent. This article develops these arguments in 4 parts. Part one briefly rehearses the history of qualified immunity doctrine and criticism that have been leveled against it. Part 2 excavates Pearson's failure, its unprecedented application of the derogation canon, to incorporate a common law defense into a novel remedial statute like Section 1983. Part 3 shows that even if the derogation canon should apply to Section 1983, the text and legislative history shows that Congress did not intend for common law immunities to bar actions brought under Section 1983. And Part 4 evaluates the significant implications of this article, which go beyond qualified immunity doctrine and addresses anticipated objections. Pearson and the emergence of modern qualified immunity doctrine. When civil rights litigants seek damages against state and local officials under 42 U.S.C. 1983 or against federal officials via Bivens actions, there are many barriers to success. Among the most closely scrutinized is the doctrine of qualified immunity, which protects officers from damages liability even when they violate the Constitution if the law was not clearly established or if the official or the officers reasonably believe they were not acting unconstitutionally. The seeds of the qualified immunity defense were sown in Tenney v. Breedlove, which concerned whether Section 1983 permitted damages claims against state legislatures. The court started by tracing the long history of the legislative immunity found at common law and in both states' federal constitutions, there we go, my bad, sorry. Federalism and separation of power principles all suggested that legislative immunity was necessary for a functioning representative democracy. Even after making the big assumption that Congress had the power to limit the freedom of state legislatures acting within their traditional sphere, the court asked whether it could make an even rasher assumption to find that Congress thought it had exercised the power to the court's framing presaged the court's framing presaged the answer no. No, because absent some evidence from the text or spelled out in debate, the court could not conclude that Congress contemplated doing away with a tradition so well grounded in history and reason by covert inclusion in the general language before us. At the same time, the court upheld absolute immunity for legislators. It recognized that the immunity might not extend to an official acting on behalf of the legislature, suggesting a potential distinction between legislature and other state officials. 16 years after Tenney, the court addressed the reach of Section 1983 in action brought against a judge and 3 police officers in Pearson v. Ray. The plaintiffs were freedom riders who were arrested while protesting segregated bus facilities in Jackson, Mississippi in September 1961. They were actually arrested because they were trying to just eat. While the Court of Appeals found that the judge was entitled to absolute immunity, Section 43, footnote 43, it interpreted the Supreme Court's decision in Monroe v. Pape to preclude any immunity for It precluded any immunity for Section 1983 claims against police officers in the Supreme Court. Judicial immunity was a low-hanging fruit. Like the legislative immunity recognized in Tenney, judicial immunity was well established at common law and necessary to preserve an independent judiciary, and the court found no clear indication in the legislative record that Congress intended to abrogate wholesale all common law immunities. For police, however, the court concluded that while there was no tradition in common law of an absolute and unqualified immunity, a more limited good faith immunity was appropriate. The court rejected the Fifth Circuit understanding of Monroe, noting that Monroe stated that Section 1983 should be read against the background of the tort liability and makes man responsible for the natural consequences of his action. In the background of the tort liability, according to the Pearson Court, supported a good faith and probable cause, at least, in case of a police officer making an arrest. The court was less clear about the source of the common law immunity for officers. Unlike the legislative or judicial immunity, it did not canvass the common law of the 18th and 19th century, but instead it referred to contemporaneous Mississippi common law doctrine from 1950s. Whether the Pearson court had intended that its good faith immunity be limited or adjudicated on a case-by-case basis, it soon became clear that the immunity had a broad reach. First, the court applied it across the board to state officials who exercise non-ministerial functions in Schuer versus Rhodes. The court relied on Pearson to find that Ohio's governor and other state officials sued after the National Guard shot and killed 4 students during anti-war protests at Kent State University were all entitled to qualified immunity of varied scope. And in Wood v. Strickland, the court relied on Pearson's Schuer and state common law to extend good faith immunity to school board members sued for damages arising from student disciplinary proceedings. I am making a note here and now. I'm going to write fucking notes because this is detrimentally important. History of qualified immunity in common law shall be the title. Actually, I will save this as that itself. Pearson v. Ray. Monroe v. Pape led to exclude, prevent from happening, make impossible. Okay, cool. Preclude any immunity for Section 19 to record low-hanging fruits. For officers, however, the court concluded intending judicial immunity. All right. No immunity for officers. In Pearson v. Ray, good faith immunity the court concluded that there was no tradition of common law and of an absolute and unqualified immunity, more limited good faith wasn't appropriate. All right. So Pape rejected it at all. And after Pearson, Schuer v. Rhodes extended good faith to we're all entitled to qualified immunity of varied scope. The good faith to governor, state officials, and the National Guard. Wood v. Strickland. Relied on Pearson for in state common law to extend good faith to school boards. Extended further to extended good faith further to school board members. I will make a dash for these things to indicate what they did, what the actions were involved. Arrested priests for breach of peace. Shot and killed a bunch of anti-war protesters. School board members for damages arising from student disciplinary proceedings. I am mildly upset by this revelation. That is upsetting. Sorry, planes are flying overhead. After Pearson, therefore the court consistently relied on the presumption against implied repeal of the common law in the court of Section 1983 immunities. Second, the most consequential, consensual, oh yeah, okay. Second, and the most consequential in Harlow v. Fitzgerald, decided in 1982, rejected the common law good faith version of qualified immunity applied in Pearson and his progeny, choosing set to an objective test that focuses on the reasonableness of the officer's behavior in light of clearly established law. So further fucking us. Cool, great, lovely, lovely. Harlow v. Fitzgerald. Undid good faith in favor of clearly established law. The court saw the good faith standard with its emphasis on the subjective intentions of the defendant as insufficiently protective against ingenious plaintiff's counsel who would create material issues of facts based on little evidence, thereby surviving summary judgment and forcing a trial or settlement. Instead, the court implemented an objective reasonableness standard to permit the resolution of any insubstantial claim on summary judgment. Much of Harlow's basic structure survives to this day if an official can establish either that the relevant constitutional law was not clear or that she reasonably believed her conduct was lawful in light of clearly established law under the circumstances as she understood them, then she is immune from damages and damages liabilities. Oh boy. What is it? The coffee defense? Cop defense argument. I was too stupid. Incompetent cop defense. Harlow expressly sought to mediate the tension between providing citizens with a remedy for constitutional violations while recognizing that claims frequently run against the innocent as well as the guilty at a cost not only to the defendant officials but to society as a whole. Over time, even though Harlow's basic standard has survived, the court has slowly come to emphasize almost exclusively the latter over the former. Protecting defendants from suit appears to be the court's prime directive. One can see this trend in the procedural accommodations made to defendants who raise the immunity defense. Defendant can invoke qualified immunity at any time at the motion to dismiss stage, after limited or full discovery through summary judgment at a trial. The court has directed lower courts to resolve qualified immunity if possible prior to trial, for the value of the immunity is effectively lost if a case is erroneously permitted to go to trial. Defendants may seek protection from discovery until the threshold legal constitution of qualified immunity is resolved. A defendant sued in federal court may seek interlocutory appeals when the defense is rejected, sometimes triggering multiple appeals in a single case of otherwise unappealable denials of motions to dismiss or summary judgments, so long as the appeals is confined to a law-based qualified immunity arguments. This exception to the final judgment rule is justified as one more tool for public officials to determine insubstantial suits promptly. The defendant-friendly trend in qualified immunity is also reflected in the gradual narrowing of what constitutes clearly established law for purposes of the defense. Over the years, the court has insisted on increased factual similarity between the prior cases and defendants' alleged conduct to overcome the immunity defense. Only a few decisions break this monotony, and those are exceptions to the rule to prove the rule because they involve rare cases in which a constitutional violation is so obvious that one would not need a prior case to establish it with clarity. But in the main, the court has spent the past
3 decades, progressively forcefully emphasizing that for for law to be clearly established, prior cases must speak with such clarity that only a plainly incompetent official would fail to see the unlawfulness of their conduct. Finally, one can see the Supreme Court's solicitude for the defendants in its tinkering with the mechanism for how clearly established law develops over time. As the law develops and becomes better established, qualified immunity becomes a less effective defense. The law cannot become clearly established unless courts resolve the predicate merits-based question of whether a plaintiff's constitutional rights were even violated by the defendant's actions in the absence of initial guidance from the Supreme Court. Some courts tended to resolve the merits question first, turning to qualified immunity only if necessary. Other courts, however, found it convenient at times to resolve qualified immunity first, for if the law was not clearly established, it was unnecessary to determine whether any constitutional violation was stated. The Supreme Court intervened and stopped the later practices in 1999 2001, directing lower courts to apply a mandatory two-step analysis to motions seeking qualified immunity. Under the Saussure two-step analysis, defendants were first required to show that, after drawing all factual inferences in plaintiff's favor, plaintiffs have not alleged facts which show the officers' conduct violated the constitutional rights. If the defendant could not meet this burden, then they were, quote, required to show that they nonetheless were entitled to qualified immunity under either of the two prongs identified above. Almost immediately, members of the court and some lower court judges criticized this mandatory sequence rule for unnecessarily forcing the judges to decide difficult constitutional questions. So in 2009, Pearson versus Callahan, the court abandoned its rule and gave lower courts discretion to decide for themselves whether to address the merits questions for immunity, the merits questions or immunity questions first. It's making me angry. Almost immediately. So I should probably write Saussure established two-step analysis required merits question first, then qualified
question last. You'd be fucking right, Graham. What does the government need immunity for? Well, sovereign immunity has been long since established since like the dawn of time that you cannot base it. It's almost impossible to force the government to abide by common law, I guess. What are they so scared of? Well, I mean, it does kind of hamper the ability of a sovereign to do their sovereign duty if they're getting sued all the time. This is also established in the Constitution. All House senators, justices, and presidents and vice presidents cannot be charged or arrested while they are under authority of the states or their group of control while they're elected. However, if they are impeached, well, qualified immunity is some offshoot idea of sovereign immunity. It's something to that effect. So they made a separate distinction early on between the sovereign and the unsovereign. So justices, senators, and whatnot get absolute immunity, and then so Monroe v. Pape had no immunities as an original thing, and then from Pearson v. Ray, it established good faith immunity. It's because okay, so the whole context behind this is that apparently there was a congressional rule in 1871, which is the Civil Rights Act of 1871. It became the what's it? USC Code subsection 1983. This section read that people who violate rights in the jurisdiction of the United States were liable for damages. However, there was a missing portion of the 1871 statute that had to be redressed and was found. God damn it, every time. And was found upon revising or researching and digging deep that any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States shall be liable to the party injured in any action at lawsuit, inequity, or other proper proceedings for redress. This, outside of this line here, is the law that we have right now. However, it should read as follows. Any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunity secured by the Constitution of the United States shall, any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding, be liable to the party injured in any action at law, suit, inequity, or other proper proceedings or for redress. So what we have today is a massive mistake that has been given too much power, because the statements here rejects the common law qualified immunity. It rejects common law ideas, ordinance ideas, regulations and customs ideas.
So if the argument succeeds in any way, and this goes to the Supreme Court and they decide in favor of undoing or following this little mistranslation here, then, qualified immunity is basically done away with. And we are once again free from oppression. Almost immediately, courts complained about forcing judges to decide difficult constitutional questions. So after that, they made Pearson v. Callahan which abandoned Saussure analysis. This should not be a partisan issue. It is not. It is not. Hopefully not. Because in this research, or in this law article, hey there, fucking poopy butthole. How you doing, little shit? Sonia Sotomayor and Justice Clarence Thomas agree on this matter in some way, shape, or form. So, it should stand to reason that Sotomayor and Thomas are in unison in the idea of overturning qualified immunity. I will not suck your asshole, poopy butthole. That is gay. Gave lower courts discretion to decide for themselves whether to address the merits question. She needs to leave her earthly domain. Sotomayor? No, I didn't assume it, Mr. Poopy Butthole. While I would typically agree that Sotomayor should leave her earthly domain, in this case, I think I find an ally in someone who opposes qualified immunity for this very limited purpose. The court justified the shift based on the concerns that the Saussure two-step analysis would lead courts to issue advisory opinions by unnecessarily deciding whether plaintiffs' allegations established a violation of law. In taking account this fear, however, the court opened itself up to a different criticism. Skipping Saussure's first step causes constitutional law to become static as courts focus on whether particular rights were clearly established rather than whether the right exists at all. And if, as empirical evidence suggests, courts do not decide whether the rights exist at all, no new clearly established law will be created, leaving victims of constitutional violations unprotected. Franca is probably in tatters right now. Because of the qualified immunity thing? Is that why you say that? There we go. I don't know. I just think Branca uses it in his arguments because it's the strongest law, and from what I know of him in his arguments, he focuses almost exclusively on the law and how it applies. I don't think he's favorable to qualified immunity unless he has stated that, and I'm absolutely wrong. But of course, I don't actually watch Branca all that often. However, I think the reason why he argues about qualified immunity in such a way is because if you apply the law as it's stated or as it is in the way that it is, qualified immunity is almost basically an impenetrable protection. So in every argument against use of force from an officer, you have to acknowledge qualified immunity to make the argument. If it becomes undone, I think his whole argument becomes about the merits of the case in the case of a police officer, and did they do the right thing, and their use of force analysis becomes more prevalent because now it's no longer are they immune under qualified immunity. It's did they use is their use of force justified? I don't know. I could be wrong though. He could actually think that qualified immunity is great and that it needs to be done. Court strengthening of qualified immunity protections over time has has generated significant academic attention. Commentators have criticized the gradually ratcheting up of the protections of the defenses of any defense offers. Many scholars, most notably Joanne Schwartz, have provided empirical evidence that undermines the court's assumption that qualified immunity is necessary to protect government officials from the threat of civil liability, perhaps because most significantly, scholars have questioned the very genesis of the doctrine, arguing that the court misconstrued the common law at the time the Section 1983 was enacted. Okay, yeah, I lost my place for a moment. The fundamental assault on the court's use of common law immunity doctrine to inform its reading of Section 1983 has persisted for decades, but has earned renewed attention in the past few years. Many years ago, scholars observed both the court's original conception of qualified immunity in Pearson was untethered from the common law of 1871, and that in any case, by the time the courts transformed the defense into the objective one based on the clearly established law, the courts had departed significantly from the common law roots. This criticism has come into sharper focus ever since the Supreme Court's Clarence Thomas referred to it in a concurrence in 2017, and this is footnote 85. See Siglar concurring in part, concurring in the judgment. Thompson opinion. Ah, fuck. In the immediate aftermath of Supreme Court, the judgment is reversed in part and vacated and remanded in part. So the background of this case was, in the immediate aftermath of September 11th terrorist attack, the federal government ordered hundreds of illegal aliens to be taken into custody and held pending determination whether a particular detainee had connections to terrorism. Respondents, 6 men of Arab or South Asian descent, were detained for a period of 3 to 6 months in the federal facility in Brooklyn. After their release, they were removed from the United States. They then filed this putative class action against petitioner and 2 groups of federal officials. The first group consisted of former Attorney General John Ashcroft, FBI Director Robert Mueller, and the former Immigration and Naturalization Service Commissioner James Ziegler. Second group consisted of facility wardens and assistant wardens. All right. The petitioners did so because their actual or apparent race, religion, or national origin in violation of the Fifth Amendment. The warden subjected them to punitive strip searches in violation of the Fourth and Fifth Amendments, and that the wardens knowingly allowed the guards to abuse them in violation of the Fifth Amendment. Respondents also brought a claim under 42 U.S.C. 1985, which forbids certain conspiracies to violate equal protection rights. District Court dismissed the claims against the executive officials, but allowed the claims against the warden to go forward. So the judgment reversed in part and vacated and remanded in part. The Second Circuit affirmed in most respects as to the wardens, but reversed as to executive officials, reinstating respondents' claim. Limited Bivens. We'll read through the Thomas opinion. I join the court's opinion except for part 4B. I write separately to express my own view. Except as part 4B, 4B concluding. All right. Petitioners are entitled to qualified immunity with respect to respondents under claim. Here, some reasonable officials in petitioners' positions would not have known with sufficient certainty that 1985-3 prohibited their joint consultation and resulting policies. There are 2 reasons. First, the conspiracy is alleged to have among officers in the same department of the federal government, and there is no clearly established law on the issue whether agents of the same executive department are distinct enough to conspire with one another within the meaning of 42 U.S.C. 1985-3. Second, open discussion among federal officers should be encouraged to help those officials reach consensus on department policies, so there is a reasonable argument that 1985-3 liability should not extend to cases like this one, as these considerations indicate the question whether the federal officials can be said to conspire in this part situation is sufficiently open to that the officials in this pursuit would not have known. So basically, yeah, here reasonable authors petitioners qualified immunity with respects. Okay. So he disagreed with that. I join the court's opinion except for Part B. Part 4B writes separately to express my view on the court's decision to remand some of the respondents' claims and my concerns about our qualified immunity precedents. With respect to the respondent's Bivens claim, I join the court to extend that it reverses the second court's ruling. The court correctly applied our precedent to hold that Bivens does not supply a cause of action against petitioners for most of the alleged Fourth and Fifth Amendment violations. It also correctly recognizes the respondent's claims against petitioner Dennis Hasty seek to extend Bivens to a new context. And the Supreme Court held that Bivens does have a cause of action for damage arising from the federal agents. The Fourth Amendment violations, Bivens must provide proof of his injuries in order to recover. The court did not reach the privilege question because the Court of Appeals did not consider the question. Justice John M. concurred in the judgment, writing the federal courts have the power to award damages for constitutional violations. Warren E. Berger dissented, arguing that doctrine of separation of powers is better served by leaving the question to Congress. He also argued that the doctrine of suppressing evidence obtained in illegal searches is insufficient to deter law enforcement. Also dissented, arguing that Congress could create the cause of action Bivens stated but has not, so the majority decision is an unconstitutional extension of judicial power. Supporting the idea that the question in this case, better left to Congress. 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 Okay. I concur with the judgment of the court vacating the Court of Appeals judgment with regards to claims against Hasty Ante at 29. I previously noted that Bivens is a relic of the heady days in this court, assumed common law powers to create cause of actions. Wilk v. Robbins. I have thus declined to extend Bivens even where it's reasonably logically applied, thereby limiting Bivens and its progeny to the precise circumstances that they involved. Internal quotations. In this would, in most cases, mean a reversal of judgments of the Court of Appeals is in order. However, in order for there to be a controlling judgment in the suit, I concur in the judgment vacating and remanding the claims against petitioner Hasty, as the disposition is the closest to my preferred approach. So he agrees with this ruling because it disagrees with Bivens. And Bivens was also a court-created statute. As for the respondents' claims under 42 U.S.C. 1985-3, I join Part 4 of the court's opinion, which holds that respondents are entitled to qualified immunity. The court correctly applies our precedent, which no party has asked us to reconsider. I write separately, however, to note my growing concern with our qualified immunity jurisprudence. The Civil Rights Act of 1871, which 1985 and more frequently litigated 1983, were originally in part established cause of action for plaintiffs to seek money damages from government officials who violated federal law. See subsection 1, 2, 17, Statutory 13, or Statute 13. Although the Act made no mention of defenses or immunities, we have to read it in harmony with general principles of tort immunities and defenses rather than in the derogation of them. We have done so because certain immunities were so well established in 1871 that we presume the Congress would have specifically so provided that it wished to abolish them. Buckley versus Fitzsimmons. Immunity is thus available under the statute if it is historically accorded in the relevant official in an analogous situation at common law, unless the statute provides some reason to think that Congress did not preserve the defense. See Tower v. Glover. In some contexts, we have conducted the common law inquiry that the statute requires. See Wyatt v. Cole. For example, we have concluded that legislatures and judges are absolutely immune from liability under 1983 for their official acts because the immunity was well established at common law in Tenney v. Brandov and Pearson v. Ray. They similarly looked to common law in holding that the prosecutor is immune from suit relating to the judicial phase of a criminal process. But see Kalina v. Fletcher, arguing that court in Imbler misunderstood 1871 common law rules, although not from suits relating to prosecutors' advice to police officers. Developing immunity doctrine for other executive officers, we also started off by applying common law rules. In Pearson, we held that police officers are not absolutely immune from 1983 claims arising from an arrest made pursuant to an unconstitutional statute because the common law never granted arresting officers that sort of immunity. Rather, we concluded that police officers could assert the defense of good faith and probable cause against the claims for an unconstitutional arrest. That defense was available against the analogous torts of false arrest and imprisonment at common law. I will just kind of hit this one last thing and then go back. Our qualified immunity precedents instead represents precisely the sort of freewheeling policy choices that we have previously disclaimed the power to make. Thomas was not a favor of qualified immunity. Even where a majority to coalesce around Justice Thomas's suggestion that the defense available at common law in 1871 should also be available in Section 1983's actions, the court would have to confront many difficult questions. Civil rights actions against federal officials are not based on Section 1983, but instead are implied directly from the Constitution under Bivens and his progeny. For these claims, the court could claim greater authority to craft judge-made defenses that depart from the common law practices, or common law principles. As for Section 1983, action turning directly to common law that existed in 1871 skips at least two analytical steps. It assumes that the gap in Section 1983 should be filled by a uniform common law when in other contexts, statutes of limitations, for example, the law governing Section 1983 varies depending on the law of the form state. Or problematically, it assumes that Congress meant for common law defenses to be incorporated sub silentio into Section 1983. Implied. Under or in silence without being noticed or taken without making a particular point of the matter in question. Oh. Oh. And right now, before I continue further with this, using code layman at dragonstreasure.com will get you 10% off of all of your purchases, and I mean all of them. Only teas, all the tea that you see right here, the Dragon's Wing membership, and the Ingenuity Strainer, the tea layers, the tea itself, the membership, and the tea, the merchandise right here. You'll be able to get 10% off of all purchases with Dragon's Treasure, of every Dragon's Treasure purchases with code Layman, and you will absolutely get 10% off. So you can enjoy fantastic tasting tea with fantastic savings. And please enjoy. This is a shorter one because I want to get back to it. However, I have been drinking the tea, and then the tea I drank today was the Magic Girl Mars, which I have to say is not my favorite, but it was still pretty good. Tasted pretty good. It has a bunch of things in it to add to flavor, but it wasn't quite for me, so hopefully you'll enjoy it better than I did. But still, code Layman for 10% off at the Dragon's Treasure. You can find a link in the description below with the link or with the code. There we go. This article focuses on the second, more importantly, analytical question and asks why the common law of 1871 is even relevant to understanding Section 1983. After all, the statute itself makes no reference to any immunity and appears to provide for liability whenever a state or actor causes injury or violating federal law. The court has established on its answer the derogation canon, which it takes to mean that absent clear language, statutes in derogation of the common law should be strictly construed. In the immunity context, the court has applied this canon to look beyond the text of Section 1983, finding implicit congressional intent to codify the common law good faith defense that the court found to be existent when Section 1983 was originally enacted. Over time, the court has repeatedly confirmed that this canon led to find absolute and qualified immunity defenses for officials sued under Section 1983. The remainder of this article evaluates why the court's reliance on this canon is misplaced and shows the consequence that flow from that conclusion. As I demonstrate below, using the canon to import a common law defense for a novel remedial statute like Section 1983 is unprecedented. And even where the derogation canon appropriate for the task explicit text makes clear that Reconstruction Congress meant to displace state law immunities such as the one initially applied in Pearson. Ultimately, rather than mediate Section 1983, liability against the backdrop of common law immunities existent during Reconstruction, as Justice Thomas and some academics have argued, qualified immunity and some aspects of absolute immunity simply are not applicable in Section 1983 litigation. The court's continued application of the defense has no basis in text, history, or doctrine. It is instead the exercise of illegitimate judicial power in the face of contrary legislative text and intent. Significantly, this means that Congress need not act to abrogate qualified immunity even if advocates would welcome legislative reform. An intellectual doctrinal history of the derogation canon. The derogation canon has checkered history, criticized by commentators since the mid-19th century. It nonetheless has played a meaningful, albeit limited, role in the Supreme Court's statutory interpretation jurisprudence. In this section, one first traces of the history of scholar treatment of the canon before turning to its development in the Supreme Court. Both commentary and case law demonstrates that even had Reconstruction legislators been aware of the derogation canon, they would have no reason to think that it would apply to incorporate common law defenses into Section 1983. Nor had developments subsequent to Reconstruction made the canon any more applicable to the Civil Rights Act of 1871. I think I'll wrap up on page 20 or 21. A scholarly treatment of the derogation canon. For more than a century, the derogation canon has been subjected to trenchant criticism, whether viewed as substantive means to privilege common law because it is its superiority to statutory law, or as a tool for discerning legislative intent. Commentators have found little to defend. The late Justice Antonin Scalia, writing with Brian Garner, rejected the canon as a canon of the court's historic hostility to the emergence of statutory law. Notably, Justice Scalia's view was as common during Reconstruction as it was when he wrote it almost 100 when it was as it was when he wrote almost 150 years later. Theodore Sedgwick's influential treatise on interpretation criticized the canon as a creature of judicial belief that common law was the perfection of human wisdom, to be jealously guarded against parliamentary intrusion. In Sedgwick's view, the modern courts and judges should realize that the doctrine does not account for the enormous changes in the relations between the courts and the legislatures which have taken place since the rule was promulgated. If ever the derogation canon served a purpose, Sedgwick maintained it had entirely passed away by the mid-19th century. The better rule for Sedgwick, which courts had coalesced around, was that remedial statutes, even ones in derogation of the common law, should be liberally construed. If the derogation canon had any value at all, it was only to protect personal liberty. Otherwise, the rule has become obsolete. The form of verbal reasoning which once supported, it has vanished, and the rule itself should be abolished. Which is a quote. The first American treatise on negligence law, written shortly before the Civil War and republished during Reconstruction, also advanced his position. Even treatise authors who were more generous to the canon and who saw it as a means to discern unclear legislative intent, such as Sir Fortunatus Dwaris, opined that that are directed to public utility, by which Dwaris seemed to mean the general public welfare, ought to receive the most liberal and benign interpretation in accordance to the maxim ut res magis valeat quam pereat. Fucking Latin. It is better for a thing to have effect than to be made void. Benign interpretation in accordance with the maxim, it is better to make things invalid than to make it void. Recognize that where legislation addressed an issue not covered by common law, as did Section 1983, determining the ends of the act can be discovered from the cause or necessity of making the act. Hence, the direction to inquire into mischief against the common law had not provided. J.G. Sutherland's 1891 treatise to statutory interpretation, like Dwaris, gave the canon some credence. But consistent with the case law summarized below, the treatise focused on statutes to take away a common law right, removed or add to common law disabilities, or provide for proceedings unknown to the common law. Sutherland included numerous cities or sites at each point, but did not discuss common law defenses. His focus instead was on common law rights and proceedings. The former included property rights and rights of action, while the latter principally referred to common law rules of evidence. 20th century commentators were no more enamored with the derogation canon. Roscoe Pound, writing in 1908, recognizes obsolescence and its grounding in an era of judicial supremacy. He defended it He defended it in limited applications, such as to guide courts away from giving a statute an interpretation that would make it unconstitutional. Beyond that, he wrote, "It is without excuse that it's merely an incident of the general attitude of courts towards legislation." From Pound's perspective, the canon's survival was rooted in judicial jealousy of the reform movement, and is wholly inapplicable to and out of place in American law today. Pound observes, for centuries, Roman law recognized that written text was the default with common law, a mere makeshift to which men resorted to for want of enactment to prevent a failure of justice. According to Pound, judge-made law overtook this tradition in England around the 17th century, in large part due to the relative paucity of legislation. Presence of something only in smaller and insufficient quantities or amounts scarcity. This, combined with the tradition of judicial review for unconstitutionality in the United States, led to the conception of the statute as something exceptional and more or less foreign to the body of legal rules in which legislation had endeavored to insert it. In Pound's view, if the canon was ever justified, it was when the court stood between the individual and the crown and protected the individual from the state when he required that protection. When deployed against legislation enacted by popular elected body, however, the justification was less compelling. And to the extent that modern authors have located the canon a notice-based justification for those who face new standards of liability, it would be difficult to conclude that the state actors were deprived of that notice with the passage of the Reconstruction Acts. Writing decades after Pound, shortly before the Supreme Court decided Tenney, Jefferson B. Fordham and J. Russell Lech examined the derogation canon anew and came to similar conclusion as the prior commentators, although Fordham and Lech differed somewhat with Pound as to whether the canon was a uniquely American construct. They shared his views with that it was indefensible as a general matter, as they observed even if some common law principles might withstand scrutiny better than some statutory innovations, that does not establish common law's presumptive superiority to statutory law. In short, over the course of 150 years, commentators have cast doubt on the utility of the derogation canon, particularly as applied to the remedial statutes such as Section 1983. And with that, I will leave it here because this is a good spot to leave at. I will save this to Legal Layman. just in case. But yeah, there's a very good argument now that the derogation canon is bad, qualified immunity is bad, and the original text of the 1871 Civil Rights Act was altered unjustly. How about that, huh? And before I wrap up the show, I want to thank you guys for watching. Thank you, Mr. Poopy Butthole, despite having the shittiest of buttholes. Graham, nice seeing you again. Thank you for joining the chat. I wanted to do this yesterday. I learned that a lawyer that I watch has gained a step towards freedom. This freedom being the freedom from good behavior publicly. And so I will say, to Good Logic, Joe Neerman of the Good Logic Show. Congratulations and mazel tov to your son's wedding. You have one down, one more to go, if I remember right. To your other son, may he find himself a gentle yintel to marry very quickly, so you can be free of the traditions of Yiddish, Hasidic, Yiddish, the language used by Jewish people in the central. It was originally German dialect, with words from Hebrew and several modern. Okay. So you can be free of the Yiddish tradition of being bound to good conduct for fear of harming your son's future prospects in marriage. May he find that gentle yintel, and may we finally freeze the Jews. Mazel tov. I'm gonna have to clip that out myself and send it to Joe Neerman, and hopefully he likes it. I wanted to say this yesterday, but I was at work, and I was like, Good Logic has a step towards freedom. May he see that freedom through. So with that, I will once again announce: use code Layman at Dragon's Treasure for 10% off of all your anime and tea-based purchases for the tea wares, the membership, and the merchandise. And you can get the herbs and spices with the membership plus the discount that I offer you. Eucalyptus has sold out. For 8, 12, 16, 20, 21, 24. I know what I'm going to do for the rest of my setup. So right here is a little section. I can basically make a foot step or a foot thing from my bed to keep it firmly pressed against the wall. That will store, that I'm thinking of making a small shelf that'll store like snacks and whatnot, and all of my tea tins, which are magnetically held together, like so. So I'll need to find out something that'll fit it. But yeah. Man, it would be kind of cool to have my own herbs and spices. Design my own flavors. With all that said, however, Dragon's Treasure, use code Layman for 10% off and enjoy fantastic tasting tea with fantastic savings. Doesn't sound like a lot, but if you purchase tea, a lot of these teas, they are high quality, but they're also pretty pricey. Or their price is appropriate for the quality that you get from the tea. So if you want to get good tea with good quality and get a good price or better price, use code Layman for 10% off. And with that, I am done with the show. Go to camera now. Yeah. But yeah. I'm determining whether or not I should do a normal show tomorrow. Because if I get it right, if I'm correct, I will have Legal Mindset on tomorrow at maybe 7 9 p.m. after 6 p.m., which is where my show typically ends. So tomorrow I will not be doing, I either will be, but doing a short reading, or I will not be doing the reading of the Federalist Papers. I'll probably save that for Saturday. So, with that said, I will let you guys know in Twitter, where you can find me at Legal Layman with 2 N's. On Locals, I will post it there at legallayman.locals.com. And I don't think I have access to community stuff yet on YouTube. And there's no community thing for Rumble either, so there's no really point doing that. Yeah, with that said, thank you for joining me. Thank you for watching. I appreciate the views. I appreciate you guys' support. It means so much to me, even the aggressive support from Poopy Butthole. NC Native, thank you for coming by. I appreciate your viewership on Rumble. Thank you, Poopy Butthole, and thank you, Graham, for joining me on the stream. I also thank everybody who will be watching on the replay. If you can't watch this because I'm out of your time zone area, I understand. I miss a bunch of shows myself. With that said, follow me and subscribe on YouTube and Rumble, all of which can be found in the descriptions below. In both sides, follow me on one and the other to support me further. Follow me on Twitter at Legal Layman with 2 N's at the very end. And at legallayman.locals.com, where I will probably be trying to do more exclusive content like singing, because I'm a choir dipshit that likes to sing. With that said, I will also try to make sure that I keep you guys posted on Locals over there, so as to make it worthwhile for the show. I think I will actually start making my generalized show announcements that I normally do on Discord to the self-promotion in the Rekieta side and the mindset side. I think I will be doing those more often. I will use it as the template form. So, with that said, I will try to update Locals more often for you guys while trying to upload more exclusive content. With that said, thank you once again. I appreciate the viewership. It means so much to me that you watch, and I'll see you tomorrow, whether that be for the Federalist paper readings that I might change to Saturday, or the 7 to 9. It should be 7 to 9. I'm thinking that's a good time frame for him for a stream. For Disney research, he'll be answering my questions on Disney, kind of the foundational. I'm using his information and his knowledge to help create a narrative around the rise and fall of the Reedy Creek District and Disney's dream. With that said, once again, thank you. I'll see you guys next time, and hang loose.